Welcome back. My guest, Silva Ogwemo, was called to the Nigerian bar in 1988. He has handled several high-profile commercial, civil, and criminal matters. As a mark of distinction, he was awarded the prestigious rank of Senior Advocate of Nigeria in 2014. Mr. Ogwemo joins me on the program now. The ongoing probe of the diversion of funds budgeted for arms procurement has once again brought to the fore the violation by politicians of election campaign financing laws in Nigeria, because most of the monies diverted were allegedly used to finance election campaigns. Why are we having this violation? Do you think that it's a problem of inadequacy of laws, or is it a problem of enforcement of the laws, or something else?
The figures we hear actually mind-boggling. I'm not going to say it has to do with inadequacy of the laws, because as it stands, the Electoral Act has adequate provisions and limitations on party spendings. In fact, the law says that every political party should in fact disclose the source of its funds, should in fact make available to the Commission, as the Electoral Commission, its assets and liabilities, and there should be an audited account of every political party. But what we hear these days is that billions and millions of naira have been spent to prosecute elections. This is clearly contrary to the Electoral Act. And I think we have laws that have specified what should be done. It is just the general problem of the country. You find a situation where laws have been made and then these laws are not implemented. And then you begin to wonder, what is our problem? Why do we act in the way we act? Is it that we have a peculiar problem? Then it comes back to observance of the rule of law. We should at all times take steps to ensure that every law that is made is obeyed. Now, in this instance, what is the Commission doing about this? Have they asked for audited accounts of the political parties? Have they asked questions about spendings? What have they done in this instance? Because the law empowers them to ask questions, to seek clarifications in terms of funding. For the presidential election, you're not supposed to spend more than 1 billion. Yes, for presidential election, because that is the limitation that has been provided under Section 91 of the Electoral Act 2010. So you begin to wonder why we're having billions and billions, even for governorship elections. Where did they get this mandate from? Where did they get this right to do this from? When the law says A, X, Z should be done, that should be it.
But do you think INEC has the capacity to enforce the legal limits on election campaign financing in the country?
Clearly, I think they should. If the law says they should ask questions and ask for clarification in terms of their assets and liabilities and source of their funding, why shouldn't they do that? The only thing I see is that there is so much focus on the conduct of the elections as against the other issues that have to do with the elections. For example, we've heard in Bayelsa, people have been murdered and killed because of elections. What are we doing about it? The same thing happened somewhere in Rivers and in some other states. What are we doing about this? Who were behind these killings? Who killed those people? Are they ghosts? Were arrests made? The state can also take up these issues, because there are criminal breaches. These are criminal acts for which the state has a right to prosecution. So the state in this instance can also deal with the culprits.
Let's talk about corruption in the judiciary. The Chief Justice of Nigeria, Justice Mahmood Mohammed, has challenged senior lawyers to come out with the identities of corrupt judges, because he believes that once they make these allegations that some judges are corrupt, then it means that they know them. But it appears that the bar has refused to take up this challenge. What do you think is responsible for this?
It is not the fact that the bar has refused to take up the challenge. The issue is this: if you say judges are corrupt, if you find one, yes, of course, complain. But if you don't find anyone, you don't have evidence relating to corruption or a corrupt judge, then of course there's nothing you can do. You cannot manufacture evidence in terms of corruption, because he who asserts in the law must prove. So if you say a judge is corrupt, they will ask for the evidence. Where's the proof that you found him doing something outside the oath of office? You should be able to substantiate.
You once said that judges should earn their salaries based on the number of cases they handle. Why did you make this suggestion?
I made that statement based on what I have seen in court. There are some judges, if you appear before them, you should be ready to do your work because the judge is ready to do his or her work. But there are courts you get to and you find a situation where the judge allows lawyers to get away with every flimsy application or reason for asking for an adjournment. But if a judge, yes, they want to stop proceedings. He's doing that in defense of his own client. But if a judge knows that his own job is at stake, his own earnings is at stake, in respect of that particular suit or case that is before him, then he would insist, because you have knowledge of that adjournment. You are aware that the case is coming up. You have been informed. You know about that date. You should be prepared to come to court to do business, not to come to court to ask for an adjournment. So where that is the case, judges should also let lawyers know that, look, my own earning is at stake. If I don't do your case, I'm not going to get paid. So you must work. So a lawyer who knows that the court is for business will come to court prepared. It's happening right now. It is happening before courts. We find judges who are ready to work. If you are before that judge, you must be prepared to work hard. You must be prepared to do your case the moment your case is called, because that particular judge is not going to entertain any application for adjournment. And lawyers do sit up and they do their work.
And what do you think that the role of the lawyers should be?
We see, we also have rules that have been made of recent, which provides for cost against a lawyer who is indolent, or against a lawyer who is not prepared to proceed, or against a lawyer who has contravened the rules of the court. The rules of court provides for cost against the lawyer. So if you are made to pay heavily for cost that is awarded against you as a lawyer, then lawyers will sit up. Then, of course, I've discovered in our client that sometimes we have not heard of cases of professional negligence. Clients should wake up to deal with lawyers where they are misadvised or where their cases are improperly handled. You find a situation where a lawyer knows that a particular issue has been settled by the Supreme Court, and then you are going back to court, you are advising your client to spend time and money to go through that same principle of law that has been established. That lawyer should be sued for professional negligence, because he is the one who has misadvised the client, and he has led him all through, maybe from the High Court up to the Supreme Court, on an issue that he knows he's not going to succeed on. So if you come back to the lawyer and say, look, I have spent 6 years in court based on your advice, and it has turned out that your advice was wrong and that you ought to know and you were wrong in what you did, you have to pay me for the cost and pay me damages for what I've suffered. Then, of course, next time you won't find lawyers who will be, going through the system just to earn money and then waste the time of the judges and his own time.
But flowing from what you said, shouldn't the judges in the same vein stop the lawyers from wasting the time of the courts, especially when the cases are already settled and decided?
Yes, clearly, that's a very good question. You see, judges should also be masters of their cases. They should be in charge. But then again, there's a problem. It depends on the way it is handled. I've watched a proceeding in the UK where a judge said, Mr. A, have you looked at this authority? Have you seen these rules of court? I'll stand this case down for you to go back and check. And the lawyer goes back, he checks, and he comes back and says, my lord, I withdraw my application. But we find a situation where a judge tells a lawyer, go check this procedure out. And then he says, oh, the judge is biased. He has taken money from the other party. He's now working on behalf of my opponent. So judges are a bit confused and reluctant to intervene. And there's, okay, well, and then there is the issue of fair hearing. Let the other party be heard. It's okay, I'll take you. But he knows. But I think judges should sit down, and maybe it could be by way of an amendment, that judges, where cases are settled, that could be a new innovation. Where cases are settled, judges should have that authority cited to the lawyer, particularly where it is coming from the Supreme Court. And the lawyer should be well informed and given maybe a stand down on adjournment to come back and inform the court. Where he refuses, and there should be some kind of cost should be awarded.
The inconsistencies in the judgments of the Court of Appeal tribunals handling election matters has continued to generate so much controversy. Lawyers are divided. But what are your thoughts to possible solutions to dealing with this issue?
Clearly, at this moment, I think we should be looking at improving on our system and processes. For example, like the Court of Appeal, they have several divisions in several states of the country. If there is a judgment from Owerri division, for example, that judgment should be circulated through all the divisions. So justices of the Court of Appeal will have foreknowledge. They have at least the opportunity of seeing that judgment and knowing what it says. And then you don't go back and say a different thing, you know, from that judge, except in situations where the facts are distinguishable or where you think that that particular judgment did not address the law as it is or as it ought to be. So in that case, well, you find problems, and then there should be an opportunity for the Supreme Court to now decide finally what the situation should be. But I think there should be a collation center. If a judgment is decided today, that judgment should be sent out to the collation center where it is now made available to all the justices of the Court of Appeal, so that we have consistency where the facts are similar, the issues are the same. You find Court A saying a different thing and Court B saying a different thing. I mean, it doesn't go well for our system. So we should have a judgment collation center where we have so many lawyers who are unemployed, where lawyers sit down, collate these judgments, and then distribute them. What can be done is, in those judgments, you don't have to give them the whole hog of it. Just summarize the facts, raise the issues, and then what was the final holding of the court. That is made available to all the judges. So you know what the issue is, you know what the judgment is, you know what the principle of law is. So we don't have to go back and begin to say a different thing by a different court on the same issue or the same facts or the same questions of law that have been raised.
Clients should move against lawyers who advise them wrongly. Costs should be awarded against lawyers who deliberately stall proceedings, and judges should be paid according to the number of cases they hear. There should also be a judgment collation center for uniformity of decisions of courts, and where cases are settled, judges should cite them to lawyers. These are just a few suggestions which Mr. Ogwemo thinks can help the justice system. What do you think? Please share your thoughts, comments, and questions using any of our social media handles. Don't forget that you can find these and past episodes of the program on our YouTube channel. I am Shola Shoyedi. Thank you for watching.